right, so both sides having closed the portion of the evidence, the next step is for me to read the charge to you. After I've read the charge, and it's rather lengthy, but you will be able to take the charge of the court back with you. We'll have closing arguments. After closing arguments is when you will begin deliberations. So I'm going to read this, and as I said before, it is rather lengthy. But you will be able to take the original back with you. Charge of the court. Ladies and gentlemen of the jury, the defendant, Uriah Urick Jr., stands charged by indictment with the felony offense of capital murder, alleged to have been committed on or about the 6th day of February 2025 in Galveston County, Texas. To this charge, the defendant has pled not guilty. Both sides will soon present final arguments. Before they do, I must now give you the instructions you must follow in deciding whether the defendant has been proved guilty or not. You will have a written copy of these instructions to take with you and use during your deliberations. First, I will tell you some general principles of law that must govern your decision of the case. Then, I will instruct you on the rules that must control your deliberations. Finally, I will tell you about the specific law applicable to this case. General principles, the indictment. The indictment is not evidence of guilt. The indictment is only a document required to bring the case before you. The indictment cannot be considered in any way by the jury. Do not consider the fact that the defendant has been arrested, confined, or indicted, or otherwise charged. You may not draw any inference of guilt from any of these circumstances. Presumption of innocence. The defendant is presumed innocent of the charge. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The law does not require a defendant to prove his innocence or produce any evidence at all, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The presumption of innocence alone is sufficient to acquit the defendant. Burden of proof. The burden of proof throughout the trial is always on the state. The defendant does not have to prove anything. So he does not have the burden to prove anything. The state must prove every element of the offense beyond a reasonable doubt to establish guilt for the offense. If the state proves every element of the offense beyond a reasonable doubt, then you must find the defendant guilty. It is not required that the state prove every element of the offense beyond all possible doubt. It is required that the state's proof excludes any and all reasonable doubt concerning the defendant's guilt. If the state does not prove every element of the offense beyond a reasonable doubt, then you must find the defendant not guilty. If, after you have considered all of the evidence and these instructions, you have a reasonable doubt about whether the defendant is guilty, you must find the defendant not guilty. Jury as fact finder. As the jurors, you review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and the weight to give their testimony. In judging the facts and the believability of the witnesses, you must apply the law provided in these instructions. Evidence. The evidence consists of testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider, discuss, or mention anything that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected with the case that is not evidence in the trial. Statements made by lawyers are not evidence. The questions asked by the attorneys are not evidence. Evidence consists of the testimony of the witnesses and the materials admitted into evidence. Nothing the judge has said or done in this case should be considered by you as an opinion about the facts of the case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. You should consider only the evidence. You are permitted to draw reasonable inferences from the testimony and exhibits that are justified in the light of common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the facts that have been established by the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is in these instructions. Do not allow your verdict to be determined by bias or prejudice. Admitted exhibits. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Testimony. Certain testimony will be read back to you by the court recorder if you request. To request the testimony be read back to you, you must follow these rules. The court will allow testimony to be read back to the jury only if the jury, in writing, signed by the foreperson, 1, states that it is requesting that testimony be read back. 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identifies the name of the witnesses who made the statement. The court will then have the court recorder read back only that part of the statement that is in disagreement. Evidence of wrongful acts possibly committed by the defendant. During the trial, you have heard evidence that the defendant may have committed wrongful acts not charged in the indictment. You are not to consider that evidence at all unless you find, beyond a reasonable doubt, that the defendant did, in fact, commit the wrongful act. Those of you who believe the defendant did the wrongful act may consider it. Even if you do find that the defendant committed a wrongful act, you may consider this evidence only for the limited purpose I have described. You may not consider this evidence to prove that the defendant is a bad person, and for this reason was likely to commit the charged offense. In other words, you should only consider this evidence only for the specific limited purpose I have described. To consider this evidence for any other purpose would be improper. Rules that control deliberations. You must follow these rules while you are deliberating and until you reach a verdict. After the closing arguments by the attorneys, you will go to the jury room. Your first task will be to pick your foreperson. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with other members on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. Number 1, you must not discuss the case with any court officer or the attorneys or anyone not on the jury. Number 2, you must not discuss the case unless all of you are present in the jury room. If anyone leaves, then you must stop your discussions about the case until all of you are present again. You must communicate with the judge only in writing, signed by the foreperson and given to the judge through the officer assigned to you. 4, you must not conduct any independent investigations, research, or experiments. 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. Your sole duty at this time is to determine whether the defendant has been proved guilty. You must restrict your deliberations to this matter. If you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your foreperson sign his or her name to that particular form that conforms to your verdict. After the closing arguments by the attorneys, you will begin your deliberations to decide your verdict. No one has the authority to communicate with you except the officer who has you in charge. After you have retired, you may communicate with this court in writing through the officer who has you in charge. Do not attempt to talk to the officer who has you in charge, or the attorneys, or the court, or anyone else concerning any questions you may have. After you have reached a unanimous verdict, the foreperson will certify thereto by filling in the appropriate form attached to this charge and signing his or her name as foreperson. Occasionally, during jury deliberations, a dispute arises as to the testimony presented. If this should occur, you shall inform the court and request that the court read the portion of the disputed testimony to you from the official transcript. You shall not rely on your notes to resolve the dispute, because those notes, if any, are not official transcripts. The dispute must be settled by the official transcript, for it is the official transcript rather than any juror's notes upon which you must base your determination of the facts and ultimately your verdict in this case. Certain testimony will be read back to you by the court recorder if you request. To request the testimony be read back, you must follow these rules. The court will allow testimony to be read back to the jury only if, in writing and signed by the foreperson, 1, states that it is requesting the testimony be read back. 2, states that it has a disagreement about a specific statement of a witness or a particular point in dispute. And 3, identifies the name of the witnesses who made the statement. The court will then have the court recorder read back only that part of the statement that is in disagreement. Any notes you have taken are for your own personal use. You may take your notes back into the jury room and consult them during deliberations, but do not show or read your notes to your fellow jurors during your deliberations. Your notes are not evidence. Each of you should rely on your own independent recollection of the evidence and not be influenced by the fact that another juror has or has not taken notes. Instructions of the court. The state accuses the defendant of having committed the offense of capital murder. Specifically, the accusation is that the defendant is guilty of capital murder. The state contends that the defendant intentionally caused the death of Tammy King by shooting Tammy King with a firearm, and the defendant was in the course of committing or attempting to commit the offense of robbery of Tammy King. A person commits an offense if the person intentionally causes the death of an individual in the course of committing or attempting to commit robbery. To prove that the defendant is guilty of capital murder, the state must prove beyond a reasonable doubt 2 elements. The elements are that 1, the defendant intentionally caused the death of an individual, and 2, this was done in the course of committing or attempting to commit robbery. A person commits the offense of murder if the person intentionally causes the death of an individual. To prove the defendant guilty of murder, the state must prove beyond a reasonable doubt 2 elements. The elements are that 1, the defendant caused the death of an individual, and 2, the defendant did this intentionally. A person causes the death of another if, but for the person's conduct, the death of the other would not have occurred. Burden of proof. The state must prove beyond a reasonable doubt the accusation of capital murder. Definitions. Intentionally causing the death of an individual. A person intentionally causes the death of an individual if the person has the conscious objective or desire to cause that death. Individual. Individual means a human being who is alive, including an unborn child at every stage of gestation from fertilization until birth. Robbery. A person commits an offense of robbery if, in the course of committing or attempting to commit theft, and with the intent to obtain or maintain control of the property, the person either 1, intentionally, knowingly, or recklessly causes bodily injury to another, or 2, intentionally or knowingly threatens or places another in fear of imminent bodily injury or death. In the course of committing or attempting to commit theft. In the course of committing or attempting to commit theft means conduct that occurs in the attempt to commit during the commission of or an immediate flight after the attempt or commission of theft. Theft. A person commits the offense of theft if the person appropriates property. Number 2, this appropriation was unlawful in that it was without the property owner's effective consent. And 3, the person did this with the intent to deprive the owner of the property. Attempt to commit theft. A person attempts to commit theft if the person, with the specific intention to commit theft, does an act amounting to more than mere preparation that tends but fails to effect a theft. Intent to cause serious bodily injury. A person intends to cause serious bodily injury to another if it is the person's conscious objective or desire to cause the serious bodily injury to another. Bodily injury. Serious bodily injury means bodily injury that creates the substantial risk of death or that causes serious permanent disfigurement or protracted loss or impairment of the function of any bodily member or organ. Application of law to facts. Although the state has charged the defendant with the offense of capital murder, you may find the defendant not guilty of the charged offense, but guilty of any lesser included offense. In this case, murder is a lesser included offense of the charge and greater offense of capital murder. You may discuss both offenses in any order you choose. Before you may find the defendant guilty of murder, however, you must first find him not guilty of capital murder. Now, bearing in mind the foregoing instructions, if you find from the evidence beyond a reasonable doubt that on or about the 6th day of February, 2025, in Galveston County, Texas, the defendant, Uriah Urick Jr., did then and there intentionally cause the death of an individual, namely Tammy King, by shooting Tammy King with a firearm, and the defendant was then and there in the course of committing or attempting to commit the offense of robbery of Tammy King, then you will find the defendant guilty of the offense of capital murder. If you all agree that the state has failed to prove beyond a reasonable doubt the defendant's guilt, then you must find the defendant not guilty. If you all agree that the state has failed to prove beyond a reasonable doubt any of the elements listed above, you must find the defendant not guilty of the offense of capital murder. You may then determine whether the state has proved beyond a reasonable doubt the lesser included offense of murder. Now, if you find from the evidence beyond a reasonable doubt that on or about the 6th day of February, 2025, in Galveston County, Texas, the defendant, Uriah Urick Jr., did then and there intentionally or knowingly cause the death of an individual, namely Tammy King, by shooting Tammy King with a firearm. If you believe from the evidence beyond a reasonable doubt that the defendant is guilty of either capital murder or murder, but you have a reasonable doubt about which of the offenses he is guilty, you must resolve the doubt in the defendant's favor. In that situation, you must find him guilty of the lesser offense of murder. If you have a reasonable doubt about whether the defendant is guilty of either offense, then you must acquit the defendant and say by your verdict, not guilty. Suitable forms for your verdict are hereto attached. The verdict must be in writing and signed by your foreperson. Your sole duty at this time is to determine the defendant's guilt or innocence of the defendant under the indictment in the case and restrict your deliberations solely to the issue of guilt or innocence of the defendant. The verdict. The law requires that you render a verdict of either guilty or not guilty. A verdict of not guilty simply means that the state's evidence does not prove the defendant guilty beyond a reasonable doubt. You may return a verdict only if all 12 of you agree on this verdict. When you reach a verdict, the foreperson should notify the court in writing. Signed, Patricia Grady, presiding judge of the 212th Judicial District Court. The verdict sheet reads as follows. Verdict of the jury. Paragraph 1. We the jury find the defendant, Uriah Urick Jr., guilty of the felony offense of capital murder as charged in the indictment. Second paragraph. We the jury find the defendant, Uriah Urick Jr., guilty of the lesser offense of murder. Final paragraph reads, we the jury find the defendant, Uriah Urick Jr., not guilty. And each paragraph has a signature line for the foreperson of the jury. Half an hour? Okay. Go ahead and get started.
Thank you, Judge. May I use the Elmo?
Yes, sir.